Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, May 19th, 2026 at 9:05 in the morning. So we're here to look at a new draft of S71. Rick, good morning. Thank you for joining us this morning. If you'd like to walk us through this, and I think committee, as if you remember on Friday, our discussions that we were going to include Connecticut 2025. There are still some instances where there's differences where we've included the kids code definitions. I don't believe that everyone is crazy about all of them. But we'll put them in. We'll hear from people on the sidelines sometime down the road when we get a chance, when we're off the floor, to see where we go. So Rick, if you'd like to walk us through it.
All right, good morning, everybody.
Can I just clarify, just one
No,
minute,
please.
or maybe
Yeah.
it's for Rick. So this document is based on S71 has passed the Senate
With 2025, with Connecticut 2025. But some of the exemptions are the same as they have been.
as passed.
No, as they have been in 3.3,
Oh, okay,
not changed because we have
Okay.
agreement on those.
I see. Okay, all right.
But, and there's some reworking, data minimization, you're gonna see that.
Okay,
It's not quite the same as what you read in Connecticut 2025, but Rick has reworked the language where he's taken A and B and kind of combined them.
okay.
So it may throw people off, but
Yeah, that's fine. I was just adjusting from what I
Yep.
was trying to compare this week.
Yeah, I think it bears mentioning, my understanding is Connecticut writes their laws different than us. So
Yeah.
there has to be some modification.
Totally.
We can't just carbon copy
No, I-
because if we did, it would conflict with stuff we already have in statute. Am I correct on that?
Good way to do
So
it.
it makes sense that you would have to make some modifications to make it compatible with what is already existing statute in the state of Vermont.
Fair way to put it. Okay, so good morning, Rick Sagel, Office of Legislative Counsel. Draft 4.2 should be on the committee webpage. And as the chair said, this is a much different draft than 3.3. The foundation of this draft is much more Senate, as passed by the Senate. Again, with the Connecticut 2025 changes, although not all of the Connecticut 2025 changes, and I'll go through that. From where I sit, I think there's some decision points, and I'll kind of highlight those as we go. The chair mentioned the definitions. That's one of those decision points. And, this is fairly towards the end of the session, and I think the committee should decide that fairly quickly so we can make this draft as good as it can be as far as legislation goes. So that's going to be one decision point. The applicability threshold will be the second decision point. The exemptions, as the chair said, those have been fairly negotiated over the past 2 years, is my understanding. And that's why the leadership wanted to keep the exemptions from 3.3 that you've all been looking at these past several weeks. And there's a few more, but those data minimization is pretty much Connecticut with a few adjustments. But those are kind of the major points I think the committee will want to make a decision on fairly soon. So the way I've highlighted this is I did not, typically the way that I work and my office works is from one draft to the next, we highlight what has changed. That was not going to be workable in this draft. This is a much different draft than 3.3. So what I've highlighted in the definitions are the definitions that do not align with Connecticut. To me, those are the decision points that you all need to make. The other definitions that are not highlighted align with Connecticut. That's the way I look at it. But that does not mean they match 3.3. Does that make sense? So in the best of worlds, you all would read this over the next day or two and reach out with questions or during committee time to talk about definitions that I've not had a chance to walk through because I can't read the bill again. So I'm going to stop at the highlights, and try to give you all these points of decisions. For example, biometric data, this is the same definition in 3.3. However, Connecticut uses a different definition of biometric data. So that's one that you want to think about is, do you want to go with this, which is the same as in the Age Appropriate Design Code Act? Also, I think is 639. Does 639 also use the same? Make sure, yes. So genetic data privacy also uses the same biometric data definition. So if that makes a difference to you all, something to consider.
Can I ask Monique a question? Because she's one of the experts. And I would like to know what the impact is. Is there an impact that's really special? Because when I look at biometric data, I don't really see where there's a problem. But I don't know if it's in there for a specific reason somewhere else.
I don't understand your question. If you're asking for the impact on industry, I would suggest hearing from industry.
My sense, Michael, is that it is this definition has more detail than in the bills passed the Senate. Whether that's helpful or not, gotta figure that out.
My understanding is, if I heard you right, is this is in other statute, that same definition, right?
In Vermont, correct?
Right, so it's already existing, so in my mind, the definition's already been vetted.
Oh, and it was in the genetic thing? This is taken from the genetic.
It's taken from Age Appropriate Design Code, which genetic privacy also took from. So,
Okay.
okay, back to the definition. So again, something to think about. Collect is not in Connecticut. So Vermont in draft 3.3 defined collect. Collect is also in so all these yellow highlights are in the Age Appropriate Design Code Act. Okay. Not to say that they should be in here, but the request from leadership was to include the definitions as they appear in Kids Code. So again, this was in draft 3.3 and it remains in draft 4.2.
I just want to flag on this. So if we do keep collect like this, and if it's still, I haven't had a chance to look at processing, but if it's still different than processing, then there is a phrase that the Business Software Alliance had a call with them on Friday, and they wrote a letter rather than testifying to explain why it's important to have the sentence that we had on the end of this, which is other than such activities between a controller and a processor, or between a processor and its subcontractors, meaning that when like between the relationship between a controller and a processor, there are processors that are technically getting information from the controller, and that should not be seen as collecting it from the controller. So it's a different relationship than collecting information from a consumer. So we don't want to interrupt the interplay business to business between a controller and a processor. So that's an important phrase. There was another spot that it needs to be updated. But if we do this, which I support this, I'm just saying we do want to respect the controller processor relationship in this definition.
So thank you. That was not that wasn't 3.3. That's my fault. So would that need to be adjusted in Kids Code as well? Something to think about, because this is what Kids Code is.
Right, and I don't know, I'm not sure of that. That's not something that was flagged on the Kids Code bills across the country. This was in this definition for the comprehensive bills. This is something that's been flagged by industry for updating comprehensive bills when they're separate. And they said it's completely fine to separate collect from processing. They just want that additional kind of line to clarify that it's the interplay of the relationship between controllers and processors.
Maybe it does not need to be defined. Would that be the?
I think it needs to be defined, yeah, but with that little.
So just decision point for the committee. Yeah.
I mean, I agree. I think that should be added. I mean, in one sense, we're kind of like saying that a bank collects income because we put our money in the bank, in the checking account.
Exactly.
It all has to do with control. Just because a processor has the data doesn't mean they can control what happens to it. Yeah. And I think that's important to make sure that, like you said, that relationship is protected.
Okay, so moving on to the next definition decision. Number 11, Consumer Reporting Agency. This is a cross-reference in the exemption section. So I've highlighted those as well because they do not exist in Connecticut like this. So if it's a definition that does not exist in Connecticut 2025, it is highlighted yellow. In this case, it's not there because their exemptions don't match up with the Vermont proposed exemptions. That's why that one is highlighted.
And so this one is from where now?
This is draft 3.3, has this definition, cross-reference.
Can I ask one question again, just about how we're going through this? My sense is we're gonna allow Rick to go through the changes he made. There may be some issues like the definition of consent that are important in some other contexts, but I'm I guess thinking of holding off on that kind of issue until Rick gets through his
I think
document.
we should try to get through this first.
Got it.
We are, also, I'm sure we're gonna hear from the chamber.
Sure.
And it may be better to hear from them first and then have
That's
our
fine.
discussions on how we,
That's fine.
and others that may want to weigh in on this draft.
Okay.
Okay, on to page 5, you have 2 more cross-references used purely for the exemption section, covered entity and credit union. These existed in 3.3. 18, de-identified data. So in de-identified data does not match Connecticut 2025. This does match the age-appropriate design code. The differences, I have, Jonathan, did you post that side-by-side of the definitions that I emailed?
I posted 4.2.
There was one other PDF in that email that you can post. So I created a side-by-side of these definitions that with Connecticut that don't align. So if you look at de-identified data, there are some differences there that you should look at, and you'll hear testimony as to whether that is appropriate or not.
And that's from 3.3.
3.3, yes. And kids code.
Oh,
Derived data, yeah, everything in yellow is either in the exemptions or is from the age appropriate design code.
okay.
Yeah. Derived data, again, is it defined in Connecticut? It is not defined in Connecticut. So find here in Vermont matches the kids code definition of derived data. Financial institution is a cross-reference in the Gramm-Leach-Bliley section of the exemptions. Genetic data is not defined in Connecticut. It is defined in 3.3 and it's defined in kids code, and that remains the same here, genetic data.
That's the same, in 639 as well.
639 adds a little bit,
I think it's a little
bit more because that bill is purely about genetic data, right? This intro paragraph is the same. I believe it 639 has some other, what it does not include. Geofence hybrid entity is a cross-reference in the exemption section. Identified or identifiable individual is defined in Connecticut, but it's a little bit different. So this matches 3.3 and the kids code bill in Vermont. The difference is that in Connecticut, I can do this one easier. Connecticut stops with indirectly. So 2025. So Vermont adds in that including phrase to the definition. The term minor is not defined in Connecticut, but it has been defined in this draft, and it's defined in kids code as that way. 34, non-public personal information is a cross-reference to the exemptions. Same with 35, patient identifying information. Personal data,
So what does that mean again, when you cross-reference to the exemptions?
meaning that at some point in exemptions, this is Gramm-Leach-Bliley 34. So that term is used as data that's exempt from the bill. So that's how this bill phrases that exemption, is non-public personal information under Gramm-Leach-Bliley.
And we're doing that because the exemption is different from S71.
S71 as passed by the Senate is an entity level Gramm-Leach-Bliley.
Right.
This is data
Doing
level.
this just to make sense of the different exemption that we got.
Yes, our
It's just the way we've-
exemptions are different.
Yeah.
Right. So that's why we needed to-
Definitions, yes.
Connecticut's entry level.
Okay, great.
Exemptions are much more smaller, or not smaller, our exemptions are smaller.
Well, see. Yeah.
I would say
Thank you.
specific. They're kind of, so Connecticut 2025 also has data level, Grammarly's Bliley. Vermont just has worded it differently.
Yeah.
Yeah. 35, patient identifying information is a cross-reference in the exemptions. Okay, personal data. In Connecticut, it's difficult for me to highlight. It is different. The does not include is the same. So B is the same as Connecticut. The A subdivision is a little bit different in Vermont. So again, they do not align, so that's why it's highlighted. Okay, going down to processor. Connecticut's does not have the another processor in its definition of control of processor. This does match the kids code, except kids code adds in a state local government entity, which is exempt in this bill. So that's been removed from processor. Okay.
Yeah, thank you.
Profiling is similar, but not exactly aligned with Connecticut, but it does align with the kids code definition of profiling. Publicly available information does not align with Connecticut 2025. It does align with the kids code and it does align with genetic data privacy, except for one. I think that this is not in genetic data privacy, the reasonable basis language, but the does not include is aligned, which that's going to be the decision point, is the subdivision B is going to be where the major differences are between this and Connecticut. Reproductive or sexual health care is a cross-reference to Vermont law. Connecticut defines it much more specifically, but Vermont has the Shield law, which is a good cross-reference to use. I believe the rest, sensitive data, this is all Connecticut aligned. The rest is aligned with Connecticut of the definitions. Any questions about those? Okay, the applicability. You may remember in S71 as it passed the Senate, the applicability was, I believe, 100,000, which was Connecticut's 2022 whenever they created it. In 2025, Connecticut lowered the threshold to 35,000 consumers, which is draft 3.3 as well. Connecticut in 2025 also added two other thresholds. They're called by some the one and dones. One way to look at it. It's my understanding is that is not acceptable to a number of members of the committee. So there's a proposal and a decision point of how to do this. So it's my understanding that 35,000 is agreed upon by the committee, at least for the most part. The other two are the sensitive data. So in Connecticut, if you control or process one sensitive data element of a Connecticut consumer, you meet the threshold in Connecticut to be applicable under the act. Number three, if you sell one piece of a Connecticut consumer's data, you're also covered by the law. So this is up for debate, decision point, but you could, instead of doing one and done, you could limit it to a certain number of collections of sensitive data. That's open for debate. And three, you could also limit it to a certain number of sales of personal data if you wanted to do that as well.
So number two, I'm not as concerned about number three if you're selling it. But I am concerned about the having it, which pushes you over into it, to the guidelines that are needed.
What did you, when you said one and done, what do you mean by that?
So I was not creative enough to come up with that. That's someone else come up with that. So if you
Just what does that mean?
if you collect one piece of sensitive data
Got it.
of a Vermonter, which could be,
Yes, I.
yep.
I'm curious to understand kind of where things are going regionally when we talk about this, because I think it seems like I would be really reluctant to get too far behind where things are going. Especially because we still have a year and a half before this thing is gonna kick in.
Just Michael, to answer the Connecticut, the law there is if you control or process the personal data of not fewer than 35,000 consumers. That's from them direct. That is regional and they have more people than we do. So their businesses are probably more likely to have higher numbers, right? So it's probably a little more generous in Vermont because we have fewer Vermonters that could even hit rights provision. So that first one, it sounded like you said you were
No,
not okay with that.
it's the second one where the minute you have any sensitive data, it pushes you over to the requirements needed.
So what's the right number? That's why not fewer than X highlighted. What's the right number for that?
You had said Connecticut is 0. correct?
One.
Say you might have a problem with
So what number do you want?
35,000. Is that, I mean,
For sensitive,
that's, see, and that's what,
So
what I'm-
that would be regionally, right? So then if you're talking about being regionally compatible, then it would be one, right? To be regionally compatible with Connecticut. So that's
So-
where what is,
right, and we need to define our terms by regional, right? Because New Hampshire has Connecticut 2022, Rhode Island has 2022, Maine doesn't have it, Mass doesn't have it, New York doesn't have it.
Michael,
Oh,
we've been down this path. I think the committee's decided that we're going with 2025, so let's not back up to 2022 or 2023. But we need to make a decision at some point, not right now, of what that number is. If we're gonna stay compatible with Connecticut 2025, then it's 1. But there can be a discussion of increasing that on sensitive data. And I think we'll hear from some others that are around the table to give us an idea of what they're thinking as well. And then we have to have a committee discussion on that. But really back up to 2022, I think is off the table because the committee decided to move forward with 2025.
Just when we do this discussion later, we have never really gone deep into what the elements of sensitive data that we're even talking about. So just curious, when we do this discussion later, can we hone in on that when we're choosing a number? Right, thanks.
Also curious to know why someplace like Connecticut, to Edie's point, has a much bigger market, went from 35,000 to 1. piece of
Well,
it.
they went from
Or
100,000
100,000.
to 35,000. But when you talk about sensitive data,
Why
a
did,
little different, so, but there can be an argument made on the control or process. I think the argument for keeping it at 1 when you're offering it for sale makes a lot of sense, right? Because those are two slightly different things.
Just a question, when we hear from witnesses, I would love to know, for the, just knowing how many people own second homes, are coming up to ski, or coming up to shop, all that kind of stuff, a lot of businesses, I would love to know how many businesses are or are not already collecting sensitive data and then are not exempt and are already going to need to comply with Connecticut, as far as if we're gonna vary from Connecticut. I'm just throwing it out there.
it's gonna be hard to get that information.
That's fine, I'm just saying, I'm gonna ask that, yeah.
It's a legitimate question.
Yeah.
okay, subsection C is highlighted because it is a carryover from 3.3. It is not in Connecticut. You know how I feel about this controlling law section. I did add a call out because the main concern to me is the Age Appropriate Design Code Act. There's a lot of crossover that businesses need to be aware of. So saying not just that the law with more privacy shall control, hey, look at this age appropriate design code law. Because if you have minors as users making up 2% of your service, then you have to comply with the age appropriate design code act. So it's not exhaustive, but it's just saying that you probably should look at this law if you haven't yet. The exemptions section is a carryover from 3.3. As I've mentioned, I have highlighted a few new things in yellow that were not in 3.3. So scrolling down to page 20, line 7, subdivision 15. There was a request because there's no entity level exemption for Graham Leach Bliley for the financial institutions. There was a request that agents, broker dealers, investment advisors, or a representative of a investment advisor, as those terms are defined in Vermont law, that are regulated by DFR or the Securities and Exchange Commission. My understanding, there's a gap between how Vermont regulates these entities and how the federal law regulates these entities, and this ensures that that gap is filled and they are also exempt from the law. I don't know if you had testimony over this, but that's my understanding.
Yeah. And I'm interested in hearing the testimony too. The way I look at these exemptions is, whether we're looking at an entity level or information data level, I'm looking for whether the data or the entity has some alternative privacy structure framework. And so, whoever's going to be testifying about FINRA and stuff, that would be what I'm hoping. You might not know that, so I'm not putting you on the spot.
I know the request. That's what I know. I don't know the details.
Yes, there we go.
So subdivision 17 is, I believe this was not in 3.3. This is healthcare providers and healthcare facilities as defined in 18 VSA 9402, provided that such providers and facilities maintain all protected health information in accordance with the requirements of 18 VSA 1881 and HIPAA, regardless of whether such providers or facilities are covered entities under HIPAA. My understanding is that there is a gap of certain direct care providers that don't take insurance, therefore aren't necessarily regulated by HIPAA, but as long as they handle the protected health information as HIPAA would require, if they were covered by HIPAA, those entities and providers would be exempt from the law.
Yeah, so the two categories I think are free clinics and practices that don't take insurance. And I've been talking with about, they're different categories. And so I'm trying to understand from folks, a little better than I, whether this deals with it appropriately. And I'm also thinking this, maybe to get ahead, about some sort of threshold, patient threshold. For that section.
Okay. 18, this was removed in 3.3 because we have subdivision 2, which is going back up to the hybrid entities. And the reason my mouse is stuck. The reason it was put back is because there is a reference to it later in the exemptions, which I'll get to here in a second. So that was added back, 18, protected health information under HIPAA. 19, the comma section was added. So a third-party administrator, as that term is defined in the third-party administrator rule, provided that the third-party administrator is subject to and in compliance with the DFR's regulation IH 2001-01, which is the privacy of consumer financial and health information. This is the DFR request.
Yeah. 20, it has the victim services organization, which we had defined in earlier drafts, and that's not defined in this one. Just want to say, I don't know if it needs to be, but that was one for you.
Victim services.
Victim services organizations was created, the definition was created for this exemption, so I don't.
Thank you. Should I put that back in? Is there? Okay. So this here, looking at 20, this is not highlighted, but the reason I brought back the HIPAA protect health information is subdivision C, data process or maintain that is necessary to retain to administer benefits for another individual relating to the individual who is the subject of the information pursuant to 18. That's the protected healthcare under HIPAA. That was, the C was in draft 3.3, but the protected health was not in it. So there was a missing cross-reference. So I think it makes sense to put it back in, but happy to hear if it should not be in.
I was just wondering if it makes more sense, this is throwing out for discussion, like for later, that since we added more HIPAA exemptions about like if it is needed for C, that we move it under C rather than having protected health information under HIPAA be its own really broad blanket exemption. Since it's only there, if it's only there for this exemption, I would suggest moving it to this exemption.
So your suggestion is that the protected health information under HIPAA, that is necessary, and add in this.
I'm just like, since we created some like blanket exemptions for stuff that we were careful, I guess, with talking to healthcare entities about making it Vermont specific, protected health information under HIPAA being a broadly not Vermont specific thing, that having that standing out there by itself as a broad thing might be too big. And if that exemption in C is reliant on 18, then maybe we just recraft that C in order to incorporate it.
I had been thinking about the same thing. I wasn't sure how the two mesh together, you know, the exemption in 2 with the exemption in 18. What impact that has, I don't know, but it seemed to at least raise a question of whether it might conflict. I don't. I saw that as something, a potential question to ask folks in terms of, hey, what does that mean?
Decision point. Okay. All right. So going back down, that's it for the exemptions. Any questions about those? Okay. So 2415D, consumer personal data rights. At this point, most of this is aligned with Connecticut. I've tried to highlight as much as I can the differences, not between draft 3.3 and this, but the difference between Connecticut 2025 and draft 4.2. I'll say a lot of this is also in draft 3.3. The language has been pretty similar throughout this several weeks process. So these are the consumer rights. You may remember, delete your data, obtain a copy of your data, opt out of targeted advertising, the sale of your data except as provided in 2015 EB, which I'll get to here in a second.
Just trying to understand. I think I get it. We talked about before applicability. Basically, we took the applicability section around sensitive data, and this has got opt-out language for personal data, right? But that wouldn't really, would that cover sensitive data? Is there any special opt-out structure for sensitive data in this consumer rights section?
So yeah, two questions. One was deleting, one was opting out. So sensitive data is under personal data, right? Sensitive data is a type of personal data. It's treated differently in some cases. But here, deleting your personal data, to me, would include deleting your sensitive data.
Correct.
Yeah.
And so, as we get a little bit further about how you effectuate that opt-out, I'd be interested in knowing, how that's done under this draft. Because I think we've dealt with different ways of consumers effectuating their rights around, whatever their genetic, it's got
Right,
whatever.
right.
And opt out doesn't, well, you got opt out, you got opt in. And so I'm just interested in seeing how, when opt out, how easy it is or how specific, I guess it is, about the consumer's right for, in terms of sensitive data.
Okay.
Too many words, sorry.
Sorry, just to confirm, are you asking about whether opt-out is more effective than opt-in?
No, I'm convinced from our discussion of the genetic data privacy that opt-in is much more, because it is much more effective than opt-out,
Yeah.
but I'm not really clear about that. I mean, because Genetic Data Act says you got to be really specific about what the specific rights are around your genetic data. And then you have to specifically, the consumer can tell, it can only opt in. So it's a clear affirmative express act to say, yeah, I'm okay with you selling my genetic data. Okay.
Yeah,
And so I'm trying to think of that sensitive data in that kind of.
yeah, okay, so I see, I think I'm understanding your point. So we're also, I think when we're talking about our little regional patchwork, our little friendship quilt that we're creating is also multi-layered in that we have the genetic data piece there too.
I think where Bolton loves my subsection C controlling law section. I know what you're talking about, where you could have a law that says you cannot sell my genetic data, right? It's opt-in. Well, if you're a direct-to-consumer genetic testing company, and if that law were to pass, it has not passed, and if the governor signs it, right, long process here, then they would look at subsection C of this bill, if this were to pass and be signed, and say, oh, well, I'm a direct-to-consumer genetic testing company. I'm also a controller, but I'm also this. So I have to do an opt-in.
Yeah, it's a higher
Right,
standard, it's a higher protection.
Right. So there could be a conflict here. That's the point of what I've been trying to say.
Conflict provision.
Yes, that's why we need to be intentional about how we enforce this, how we make it clear what the priorities are. Right. Okay, again, this mostly matches, I hate to say exactly, but there's much alignment between 3.3 and this draft. The Connecticut alignment is here with 2025 and 4.2. So I'm just going to keep scrolling until I see highlights. This is just a call out that Connecticut does not have this cross-reference that I thought was important, that this is actually what you're referring to. 2415 EC is the privacy notice that a controller must have available. This is the agent that the consumer can use for the opt-out only. That matches Connecticut's, that you can have an agent just for that one right to opt out. 3.3 had it for several of those consumer rights. There's a lot here. You guys you're gonna have to compare it to 3.3. Control compliance. This is the 45-day. Very, very similar to 3.3. The authentication, 1 through 4, that matches. It matches Connecticut. I think it also matches 3.3. Third-party data. I'm on page, sorry, I'm going fast. Page 28, third-party data.
We're just gonna do the highlights.
I know, but I just feel like there's a lot here. Okay, so going down to the data minimization, as the chair mentioned earlier, this mostly matches Connecticut 2025. However, if you may remember, Connecticut 2025 tried to match or tried to implement California's rulemaking that defined what is reasonably and proportionate to a consumer's use for data. And the request was to remove that Connecticut attempt and to rework that initial minimization piece. So the way this reads is very similar to Connecticut, except it removes those Romanettes that Connecticut has, and it combines their, I believe it's A and B is how they have it organized. So the way it reads is limit the collection of personal data to what is reasonably necessary and proportionate in relation to the purposes for which such data are processed, as disclosed to the consumer, and unless the controller obtains the consumer's consent, not process the consumer's personal data for any material new purpose that is neither reasonably necessary to nor compatible with the purposes that were disclosed to the consumer.
Yeah, and that last phrase is, I think, the key one for me. Because it sort of embodies well, maybe it does. I'm thinking, notice, disclosure, and consent is sort of the framework there because of that last phrase. And somewhere I thought 2.3 and 3.3 did a little different. I could be wrong. I thought it put a period.
This is different. This is different than 3.3.
This is Connecticut.
Yeah, this is more Connecticut.
Right, so I want to flag that.
2 matches Connecticut. 3 is organized, I think, better than Connecticut. So just gonna toot my own horn. Speaking of processing sensitive data, so A is word for word Connecticut. B, adding in subdivision 9, a cross-reference, which is the age-appropriate design code kind of reminder, which is different, obviously, than Connecticut. 4 matches Connecticut and I think 3.3, 5, 6. So revoking consent, not selling the data without the consumer's consent, sensitive data, sorry. 7, another minor child. I guess in this case, it would be a minor where a controller has actual knowledge and willfully disregards the consumer is at least 13 of age, but younger than 18, also ensuring them they look at the kids code law. Because kids code has different regulations when it comes to processing the data of a minor. Okay, 9, if the controller is a covered business, which is a definition in kids code law, and the consumer is a covered minor, they shall comply with the requirements set forth in Chapter 62, Subchapter 6 of the Age Appropriate Design Code Act. This is not really adding anything. This is just ensuring that if you are a controller and you happen to be also a covered business, you have to abide by this as well.
Giving more information to whoever reads this.
Right.
Business to understand what their duties are.
Limitations. So earlier I mentioned that you can opt out of the selling of your personal data except as provided in this. So this is the except as were provided. This again mostly matches 3.3 matches Connecticut, and this is the loyalty offers with a company. That's the exception to selling your data. Opting out of that.
Just wonder if we could just flag it for a discussion point for when we do this later, a big difference between, if not a massive difference between what we have right now, and what we had in 3.3 is, hard, prohibition on the sale of sensitive data. And many states have moved, especially this year in particular, to, if not doing a hard ban on the sale of sensitive data like Maryland, Virginia, or to other states like Connecticut itself on banning the sale of precise geolocation. Even New Hampshire and Rhode Island are looking at this, and or have done it. So just would love that to be a discussion point.
Any more questions about the data minimization section?
Not in terms of technicals.
Okay. Okay, privacy notice. I don't believe there's any differences here between Connecticut and 4.2. Nope. Gonna keep scrolling. Gonna keep scrolling. We're on page 37. So we're at section 2415, processors' duties, contracts between controllers and processors. I have kept all the section headings the same. and all the subsection headings the same. Hopefully easier to compare if you are looking at 3.3 and 4.2. This is aligned with Connecticut 2025. 2415G, data protection and impact assessments, disclosure to the AG. This is aligned with Connecticut. Keep going. Okay, 2415H, de-identify data. Remember, the definitions are different, right? So that's important to keep in mind that the Connecticut definition is not aligned with Vermont. So the section may be the same, but the words have different meanings. Okay, going down to the construction of duties. So the first highlight here is this was in 3.3, the shield law. Again, kind of like kids code where we have this law in place. You want to make sure that a controller processor understands that Vermont has this protection in place. Okay, I'm on page 50. And I believe we are going to see this was in 3.3, the prohibition on law enforcement using facial recognition technology. So that to ensure that that is still good law and not authorizing the use of that by law enforcement. Then we reach enforcement, I believe. Yep, on page 55. So the enforcement is through the Consumer Protection Act, like it was in draft 3.3. The AG has the same authority under that act as it does in this law, as it does in the Consumer Protection Act. However, a consumer does not have a private right of action. That is the last sentence of that first paragraph. But everything else, the AG can make civil investigations, rulemaking, everything else in that act is given to the AG in subsection A.
In that subsection, in that chapter, does the Attorney General also have the ability to provide a cure period
They can. They're not required to.
that prohibits something?
Right. That's right. Reporting, so on December 1st of each year, they would submit a report to the General Assembly, mostly about the enforcement, if they've issued violations, the nature of each violation, the number that have resulted in enforcement, how many proceeded to trial, and any other matter the AG deems relevant for the report. This guidance, I think, is new. I didn't highlight it, but the whole enforcement section does not match Connecticut. Connecticut has a whole different, way of doing their enforcement. The AG shall provide and update as necessary guidance to controllers and processors for compliance with the terms of the Vermont Data Privacy and Online Surveillance Act. If you want to be more detailed, you can be more detailed. That's not very detailed.
You can say shall work with X, Y, and Z groups, right?
Sure.
You could do any kind of different things like that to make. In coordination with, or, yeah.
Okay, the consumer health data privacy. I'm almost done. Yep, it's always at the end. For some reason, Connecticut has done this too, where the consumer health data privacy section is again specific to entities that handle consumer health data. So it's same language about that was in Connecticut's 2025. And the effective date stays the same as in draft 3.3, which is January 1st, 2028.
That's all about Martin per hour.
Oh, process it.
Transfer it.
So,
I don't know opting out.
They're on the flip.
yeah.
I think that it sounds like probably the around 11-ish. I had to put a specific time down. Um, we need to have a conversation with Rick on this. Well, so, we're back on the floor at 1. So I would say could be afternoon, whenever we finish the floor. And if we just recess, I'll come back here.
Right.
And I would say this week, when we recess out the floor, come back here just for instruction to know what's going on. It'd be helpful if everyone would just come right back here, we'll let me know what's going on.
Don't have to collect it.
Herding cats is, although we're getting good at it, we're not that good.
What are we doing at 11? Yeah.
Just come back here, just see what's
Okay.
happening. Got it. Yeah, there may be caucuses too.
All right.
Yeah, but we have to start thinking about scheduling people to come in. as well. Start working.